What does it mean when you start a medical malpractice case against a careless doctor and careless hospital staff? And now, in response to the allegations you have made, the defense, the attorneys who represent the doctor and the hospital staff, turn around and say, you know what? You, the injured patient, have not started your lawsuit in a timely fashion. You have not brought your case within the statute of limitations. What does that mean if, in fact, you believe you did? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Now, this is a very, very serious question, and it's one that's going to have significant implications for you and your case. And you should know that if it turns out that your case is not timely, and you tried to file or you went ahead and filed the case after having an expert confirm that you had a valid case, now, if the defense turns around and says, hey, listen, you guys, regardless of what your merits of the case are, you are not timely. In that instance, we will ultimately make a request to the court. It's known as making a motion for summary judgment to dismiss your case. Why? Because you did not file it in a timely manner. And that could be deadly if that is true. If you filed your lawsuit and were not timely, now, the defense will go ahead and make their motion. They'll make their formal written request to the court. And if they are correct, your case will be dismissed. Why? Because you did not timely file your lawsuit. And no matter what happened to you, no matter what was done wrong by any doctor or hospital staff, no matter how bad your injuries were, if you do not timely file your case, the court will throw your case out. So now let's explore the scenario I described in the title of this video. You and your attorney believe, and your expert believes, that your case was filed in a timely manner. Your attorney believes that after reviewing all of the medical records, that now you still have time in which to file your case. However, the time is getting close. You are close to letting that time lapse. And now your attorney hires a medical expert who confirms that you have a valid case, that the doctor departed from the standard of care, and the hospital staff as well, and that their wrongdoing caused and contributed to your injuries, and that your injuries are significant and permanent. In that instance, even though you may have days left in which to file your lawsuit, as a knee-jerk reaction in almost every scenario in New York, the defense attorneys are going to claim that you did not timely file your lawsuit. Now, if you actually take out pen and paper and take out the calendar, and now you begin to calculate exactly how many days you have left before the statute of limitation expires, I guarantee you that the defense will, as part of the answers to your allegations about wrongdoing in this particular case, they will also claim as an affirmative defense. They will now argue, listen, regardless of any claims you are making, your case is not timely. And they will do that even though they may actually come to the conclusion that you have a few days left in which to timely file your case. Now, why would they do that as a knee-jerk reaction? Why would they do that as a pro forma matter, meaning that they're automatically going to do it? They're going to do it primarily to protect themselves. Now, you should know something. When the attorneys for the doctors and the hospital staff go ahead and answer the allegations in your case, they have to go through line by line and either admit or deny each of the allegations you are raising. They have to answer the allegations that if they are neither admitting nor denying, they can turn around and say, look, we don't have enough information upon which to give you a definite answer at this point. Now, those are basically the three choices that they have. Either admit it, which they will never do, or deny it, which they will almost always do, or turn around and say, you know what, we just don't have the right information now at our fingertips. We will supplement this at a later date. So after they answer each of the allegations, the defense also will now turn and point fingers at you, the injured patient, and they will try and argue everything under the sun about why technically you do not have a valid case. They will argue that your attorney did not properly plead the necessary items in order to establish that you had a valid case. They will argue that you are not timely in bringing your case. They will argue many different things, such as that the doctor was not properly and timely served with the lawsuit papers. That's known as an affirmative defense of lack of jurisdiction. So let's say, for example, that the defense attorneys raise 4, 5, 6 different affirmative defenses. And you might ask, why are they doing this? They're doing this to protect themselves. And the reality is, if they fail to raise every possible objection now, and to raise what's known as an affirmative defense now when they answer the allegations in the lawsuit, they most likely will be deemed waived. Now, what does that mean? It means if they don't bring that up now, if they try and address it or bring it up at a later date, and they have failed to include it in the answer to the allegations, now they're going to have a very tough hurdle to overcome to say that it was not waived. Because the whole point of answering the allegations is to say, look, let's narrow down the issues in this case, either admit or deny each of the allegations being raised, and then you, the defense, can determine whether or not there are certain technical reasons why this case may not be valid, why it should be thrown out, why the complaint was not properly worded, why things were not done the way they should have been done. In that instance, if they fail to raise some of those objections and fail to raise those defenses, many times a court is going to turn around and say, you, the defense, have now waived your opportunity to raise that. So let's get back to the question I raised at the beginning of this video. If your matter has been timely filed, let's say you have a few days left on the statute of limitations, if the defense does not raise that, and now there has been a mistake in the calculation as to whether or not your matter may be timely, if they fail to raise that defense, and it turns out they are actually right, now what will happen? They may have a good argument that your case, in fact, is not timely. And if they did not raise it at the time that they addressed these allegations in the complaint in a document called an answer and their affirmative defenses, they may not be able to raise it later on. So that explains why they are going to raise it, even if after calculating it, they believe that you are correct and still have a few days left. Just to make sure, they're going to put that defense in there. So why do I raise this with you? Why do I share this information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.